So good morning, good afternoon, good evening, depending on when you are watching the video. This is a video on contracts. These videos are intended to be short, clear, and concise about what to expect out of questions on the actual real estate exam, national real estate exam. I'm primarily dealing with people in Ohio, but this goes for anyone that's trying to take the national portion of the exam. So, um, I wanted to start out by starting with the contract section itself and define contracts and what a contract is based on the way that we need to be looking at them as real estate practitioners. So, contract per the manual that the class has, the definition of a contract is an agreement between two or more parties who have a meeting of the minds and have pledged to perform or refrain from performing some act. So we're either going to do something or we're not going to do something, and we're going to agree to do that. And so that is the essence of a contract, and the foundation of that is the meeting of the minds, the offer and acceptance of that contract. Now, contract statuses, we have multiple contract statuses, but really I'm only going to focus on three of them. We have valid, but not enforceable. Typically, you get those out of verbal contracts. Um, and then we have void and voidable. So the ones that we're going to focus on are valid, void, and voidable for this short video. Write this down, contract status, valid, void, and voidable. Those are going to be some of the main categories that they're going to be trying to test you on. Do you know what it is to have a valid contract? Do you know what it is to have a void contract, and what circumstances make a contract voidable? So write those three down. Make sure that you have a good understanding of those three statuses. So let's start off with valid contract. What makes a contract valid? A contract that's valid has all of the necessary tenets of contract validity, meaning that there's four things for our class is going to be four, but some people teach five, and I'll go over the fifth one as well. But for our class in our section is going to be the four things that make a contract valid. So what makes a contract valid is going to be competent parties, mutual consent, valuable consideration, and legal purpose. And some people teach a fifth thing called voluntary act of good faith. For our class, again, we're only going to be dealing with those four: competent parties, mutual consent, and a valuable consideration and legal purpose. So if you have those four things, you have contract validity. You have a valid contract, and the contract is enforceable. Um, Now, moving on to the next, and write that down. Those four things make a valid contract. And I must stress that if you do not have one of those four things, you do not have a valid contract. Some people will say, well, I got competent parties, I got mutual consent, legal purpose, but there's been no consideration pledged. There's been nothing of value or nothing promised in the agreement, and so the contract is valid. Some people may say, "Hey, I got valuable consideration, mutual consent, competent parties," but what you're trying to, but you don't have legal purpose, and what the buyer is trying to do with the property is not legal. So if you don't have legal purpose, you can't contract to something that's illegal. So then you don't have a valid contract because it's missing one of the tenets of contract validity. So what we really are going to focus on in this video is going to be the voidable contract status. But before we go into that, I wanted to go over what makes it void. The void is pretty simple. It's missing one of those four main tenets: competent parties, mutual consent, valuable consideration, and legal purpose. If you are missing any one of those, write that down. And I'll also write down the four tenets that make a contract valid: competent parties, mutual consent, valuable consideration, and legal purpose. You need to know those like the back of your hand. Contracts is about 20% of the real estate exam. So you're gonna have about 14 to 16 questions on there. It's 80 questions on the test. So you're gonna have about 14 to 16 questions just on contracts. And if you can nail this category, you'll go a long way in terms of putting yourself in a position of passing the test. So, contract validity, you have what is a void contract? Not valid as unenforceable because it lacks one of the main tenets. And that's I would just keep it that simple. It's a contract is void if it's missing one of the four tenants to having contract validity. Again, those four tenants, you should write these down: competent parties, mutual consent, valuable consideration, and legal purpose. Now, most of the stuff on the test is going to test your knowledge of what happens when you have a valid contract and then it becomes voidable. A lot of the answers on the test are probably likely going to be voidable when they ask you questions about contract validity on the test. But we still need to know what a valid contract is, and we still need to know how to identify a void contract. But avoidable this is what a voidable contract is, and you just write this down or remember it. A voidable contract may be rescinded due to some subsequent discoveries. If performed, cannot change the outcome. Okay, so what that means, let's focus on the first part. A voidable contract means that you had contract validity, but you had a valid contract, but the contract due to something that happened after you had the valid contract, something happened after that that made the contract voidable. Meaning, I know when we're watching videos, we'll always use like that for a given example of like the color of a house. When you went to go see the house was white, and then you went to do the final walkthrough, and now the house is blue. Some people will say that that's a substantial change in the property that you were purchasing, and you were buying a white house versus a blue house. You could avoid the contract if you really wanted a white house versus a blue house. But some people may say, "Hey, the blue house looks better. I'll go ahead and keep it." That's an example of something that happened after the house being painted from white to blue that could change the contract status from being valid to voidable. But if that person that is the decision maker in determining if the contract is going to be voidable, or if they're going to stay in the contract, that person now has a choice because of that subsequent event that happened after you have validity. So you really want to know and understand what a voidable contract is. That is a contract that had all four of the tenants and the contract was valid. But then some event after the contract was entered into happened to cause it to be voidable, or allowing one of the parties out of the contract without any recourse from the other party. So let's go take a look at some of the questions that some of the just the general questions that they will ask when we're talking about voidable, some of the voidable questions. And I'm going to go over more of these, but this is just a short video just to give you some of the examples of some of the questions that we see on the test that can kind of trip you up. I'm going to read the question and then try to unpack it. And right here it says situations where a contract can become, just kind of move this. Situations where the contract becomes voidable. So let me read the first question. Buyer enters into a contract for a residence. After the inspection, it's discovered that the seller knowingly omitted significant foundation issues. What's the most appropriate action for the buyer? There's a number of actions that the buyer can take. One of them being that once they found out that the seller knowingly omitted significant information, they probably are going to get out of that contract. That's just a bad situation. But what is this question asking you? It's asking you, do you know that this is a voidable contract situation? In the question itself. So what could the buyer do? The buyer could say, hey, let's do a price adjustment to the purchase price to account for the foundation issues, or seller, you have the foundation issues corrected before we close, or seller, you escrow some money so I can get the foundation fixed. They could say that, or they could say, since you omitted significant material facts about the property, I want to rescind the contract. And in this instance, the question is recommending the rescission of the contract, which means that the parties are going to dissolve the contract and get out of the contract and be returned back to their positions before the contract was even entered. So the answer to this contract per the book, or the answer to this question per the book is to rescind the contract is the most appropriate action for the buyer under these circumstances. Rescission is a remedy that nullifies the contract, returning both parties to the pre-contractual state as if the contract had never been made. This action is justified when there has been significant misrepresentation or omission that goes to the heart of the contract, such as knowingly hiding defects, like foundation issues. Rescission is particularly suitable here because it addresses the breach's fundamental nature, allowing the buyer to walk away from the transaction that was entered into under false pretenses. So in this instance, it may just be best to rescind the contract, but this is a avoidable situation where there could be a number of things that could be done. But in this instance, this negotiation probably was sour because one of the parties to the contract knowingly omitted significant information, and that's just going to erode the trust. But the main thing is for the test, you have to know what avoidable, how to identify a situation what avoidable contract is. Again, void contracts lack one of the major tenets, maybe more. A contract that's valid has all of the four tenets of a valid contract. And avoidable was a valid contract, but then something happened after it was valid to cause it to be voidable. And then one of the parties had a choice to either stay in the contract or get out. Let's look at another question that I just want to go over, just coming as just a thought rationale and application of some of the stuff in real life. Number two says a buyer discovers that the square footage of a property was significantly overstated in the contract. What is the most appropriate action for the buyer? Now, in this instance, this is a serious instance too. So let me give you an example. Let's use this question as an example. Say, for instance, the property, a seller was depicting the property be a 2,000 square foot property. And then during an appraisal, the appraiser measured the property and found out that the property was 1,600 square feet. Well, going from 2,000 to 1,600 square feet is a 20% reduction in living area. So a person may say, well, that's a too big of a margin for me. I thought I was buying a 2,000 square foot property for, say, 200,000. Now I'm buying a 1,600 square foot property, say, for 200,000. I think I want to just go ahead and get out of this contract because that's too big of a difference. I need 2,000 square feet. And there's really nothing that the seller can do to add that additional space outside adding an addition, and that's going to incur more costs. So that in this instance, the buyer would rescind the contract, and the contract becomes voidable because of the error and inaccurate information that was the foundation of the original contract. So when something happens, so in this instance, let's ask ourselves, what happened? Okay, we had a valid contract. Both parties thought, the seller thought that he or she was selling a 2,000 square foot property, and the buyer thought that they were buying a 2,000 square foot property. Again, through an appraisal, because that's the likely place where you will find this erroneous information, is that the appraiser is going to come out, measure the property for their assignment to value for the bank if there's financing. So the appraiser measured the property and it came back and it was 1,600 square feet, very different from what was originally agreed to. That was the subsequent event. The appraisal finding that the property was 1,600 square feet versus it really being 2,000 square feet. So because of that event, that's a material change. That's a huge change in the actual negotiation of the contract. We was negotiating a 2,000 square foot property, and it ultimately ended up being 1,600 square feet. So what I'm saying is that you have to understand the flow of avoidable contract. First, it was valid, then something happened that made the person be able, one of the parties, the buyer or the seller, be able to get out of the contract due to some significant change in the terms that was originally negotiated. In this instance, we thought we were getting a 2,000 square foot property. We were getting a 1,600 square foot property, and that allows for the buyer to get out of that situation. So the answer to this question, and again, the main purpose of this video is to have you understand the difference between a valid, void, and voidable contract, right? And being able to understand how to just the process of just thinking through some of this stuff. All right. So the answer to that second question about the square footage is rescinding the contract due to misrepresentation is the correct course of action. in this scenario. Rescission is a remedy that nullifies the contract and restores both parties to their original positions as if the contract had never been executed. This remedy is particularly appropriate when the fundamental aspect of the contract, such as size of the property is being purchased, has been misrepresented. Rescission based on the principle that the contract should be formed with the free and informed consent of both parties. When significant misrepresentations occur, it undermines this consent, justifying the rescission of the contract. In this case, the significant overstatement of the property square footage directly impacts the buyer's decision making and the value they receive, making the rescission a justifiable remedy. So it's the key to the avoidable identifying avoidable contract is that yes, we had a valid contract, but something happened after the contract was entered into and the valid contract was established that now makes it avoidable or one of the parties to have a choice to stay in the contract or stay out or get out of the contract. Now, once you make your decision to stay in the contract, say for instance, in this instance with the 1,600 square foot issue, you can then 2, 3, 4 months later say, oh, you know what, I think I should have just got it out of that contract and I want to get out of that contract. When you have an option to make it either avoidable, I mean, to go through with the contract or make it void. You can't come back after you make a decision to do one thing and then say, hey, I think I should have went this way. Once you agree to which way you're going to go with the contract, that's which way you have to stay head down down that road. So just to recap, this was a pretty short section of. I just wanted to do something quick to just make sure you understand the importance of number one, knowing what a contract is. Number two, knowing the four elements of a contract validity: mutual consent, legal purpose, consideration, and competent parties. You need to know those like the back of your hand because those are the four things that make up the contract valid. Once we have a valid contract, then and we've entered into a valid contract, there has to be some subsequent event that occurs that makes the contract voidable. And that subsequent event could be many of things. And so this is just a short video. I'll do more like this, and we're going to look at questions like this one. These were questions about situations to where a contract becomes voidable. And there's multiple situations. We'll go over those many times throughout the class. So I hope this was helpful, and stay tuned for the rest of the videos from the contract section.